Hello and welcome to IST, the program where we interview leading international personalities about their work and their areas of expertise in the hope that we can offer our viewers a glimpse into a diverse range of global issues and ideas. I'm Siddharth Varadarajan, and today we are honored to have a very special guest with us, Judge Peter Tomka, President of the International Court of Justice. The ICJ, also sometimes called the World Court, was established by the United Nations in 1945. It consists of 15 judges and is located in The Hague, which is also home to another more recent court with which it must never be confused, the International Criminal Court, or ICC. Unlike the ICJ cannot hear cases against individuals. Its remit is to settle legal disputes between states, in other words, countries. It also offers advisory opinions on legal questions submitted to it by the organs of the United Nations. In its history, a total of 161 cases have been filed with the ICJ. There are at present 14 cases pending before the court, including, and this should be of special interest to our viewers, one case where the tiny Pacific Ocean country of the Marshall Islands has accused India of violating its obligations to get rid of nuclear weapons. Around 71 countries have accepted what is called the ICJ's compulsory jurisdiction, though many, like India, have entered conditions called reservations in international law. For all other countries, including, for example, the United States, Russia, and China, the court can take up contentious cases against them only if they agree to subject themselves to its jurisdiction. Now, Judge Tomka, the Marshall Islands case is a current case, so I wouldn't expect you to comment on that. But how valid is it to call the ICJ a world court rather than a court of a limited number of countries that have agreed to subject themselves to its jurisdiction, that too subject to a number of conditions or reservations?
Well, International Court of Justice is truly a world court. We are the court of the United Nations. United Nations is a community of all sovereign states. And we are not only principal judicial organ of the United Nations, but also one of the 6 main organs of the United Nations. And we have had cases coming from all corners of the world. It's true that only 71 countries have accepted our jurisdiction by way of making a declaration recognizing jurisdiction of the court with any other country which has made a similar declaration for the future. But also some other states which have not yet made such declaration have accepted in a limited way our jurisdiction, for instance, when they ratified international conventions and treaties which contain compromissory clauses providing for the jurisdiction in relation to disputes relating to implementation or application of such conventions. So even states which have not made declaration and nevertheless recognize our jurisdiction. I would give you an example. Some states are parties to human rights conventions, and one of these conventions, Convention on the Elimination of All Forms of Racial Discrimination, provides that disputes in relation concerning the implementation or interpretation of that convention can be brought to the court by either of the parties to the dispute.
Right. But what would it take in, I suppose in political or legal terms, for powerful states like the US, Russia, and China to accept compulsory jurisdiction of the ICJ?
Well,
I mean, could the court be truly effective without the full backing and participation of these states, not just in terms of jurisdiction, but even in terms of agreeing to enforce orders as and when, as you pointed out, conditions arise where the court has jurisdiction? The Mexican prisoner case, for example, with the US, you pass orders and these aren't enforced.
I would say that overall majority of the decisions of the court are complied with. Under the statute, our decisions are binding, final, and the states have accepted the commitment to comply with them. In few cases, there were problems with the implementation. You have mentioned the Avena case, which is the case between Mexico and the United States. And on the part of the US administration, there was effort. President issued executive order inviting or ordering the compliance with that decision. Under that decision, the judgments of US courts had to be subject of review and reconsideration. But that order was challenged by Texas in the US Supreme Court. And the US Supreme Court in Medellin case ruled that decisions of the court are not self-executing, nor obligations under the Charter of the United Nations or statute, which is part of the Charter of the United Nations. So United States certainly still have this obligation, because it's obligation which is based on the judgment of the court and the Charter of the United Nations. And it's for the United States to find a way to implement that obligation.
Right.
Most likely it requires legislative action, as it was pointed out in the decision of the US Supreme Court, right, which has not questioned the decision of the International Court of Justice.
Right. One of the anomalies when it comes to the composition of the court is that even though the ICJ statute says that members will come regardless of their national status, in other words, their own nationality should not be a factor. But the fact is that the 5 permanent members of the Security Council, by convention, always have their judges on the court. Do you think there's need to relook this? Is it time, for example, if one were to say, or to think about a world where only those countries which accept the compulsory jurisdiction of the ICJ should get to have a judge? Do you think that could be one way to bring about not just a fairer composition, but also perhaps help the court be more effective?
Well, in my view, the court is and remains effective. In the composition, the court should reflect main legal system and different cultures. There is no prerogative of permanent members having their nationals elected, but as you pointed out, the practice leads to this outcome. There was a period of some 18 years when there was no Chinese national on the bench, because nobody has been nominated or was nominated in the elections. It's for member states to decide whom they wish to have on the bench, in whom they have trust that they would exercise the judicial function independently and impartially. So, but also states which have not generally recognized our jurisdiction, nevertheless, in certain situations recognize it under the multilateral convention or bilateral treaties. For instance, the United States have concluded a number of treaties on friendship, commerce, and navigation, which provide for the jurisdiction of the court. For instance, Iran brought a case against the United States on the basis of that treaty concluded in 1955. So it would not be correct to say that these states do not recognize our jurisdiction altogether, in a limited way. Or sometimes they are willing to conclude special agreements when the dispute has already arisen, and they agree with the other party to the dispute to bring jointly the dispute to the court. United States brought in this way a case with Canada in early 80s concerning the maritime boundary in the Gulf of Maine. Right.
You mentioned the necessity for judges to come from a variety of legal systems. In practical terms, how well does that work? I mean, how easy is it for judges coming from different judicial, social, cultural backgrounds, or different legal traditions? How easy or difficult is it for them to work together on the kind of cases which come up before the ICJ?
I think that this variety of backgrounds enriches our work. On the other side, international law is our common language, and there is just one international law. So I think that as a collegiate body, we work quite well.
Right. What's the average time that a case, I mean, is there an average time by which a case is filed and then is resolved? And are there steps that you could take as president to speed up this process?
Well, in average, it takes some 3 to 4 years to resolve the dispute. I admit that in the past, there were cases in which the process lasted much longer, even almost some 15 years. But there were also cases when the court proceeded rather speedily. For instance, the dispute concerning the boundary between 2 African countries, Burkina Faso and Niger. The court resolved it in less than 2.5 years. The court has streamlined its proceedings. Now here's several cases in parallel, because one is also to recognize that and realize that we are not only the highest court of the international community, but also we are the court of first instance. We have to deal with evidence first to establish the factual situation and then apply law. We are not like national supreme courts, which usually deal with only interpretation of national statutes, interpretation of law. We have to deal with facts. And length of proceedings sometimes depends also on the parties. We recognize that our clients are sovereign states, and they wish to have sufficient time to present their case. And we wish that they have full confidence that they were given opportunity to present fully their case, as our decisions are final. There is no appeal. So we should be also careful not to commit any mistake.
Right. Sometimes, of course, cases that are settled, the state, the parties to that case have opportunity to come back. The Thailand, Cambodia case, for example. How rare is that, or how common is that somebody wishes to reopen a case on the basis of new evidence or new facts?
In case of Cambodia, Thailand, that was not reopening the case, that was the issue of interpretation. The two parties interpreted differently the judgment which was rendered by the court in 1962.
Right.
And under that judgment, the temple of Preah Vihear was found to be in the territory of Cambodia.
Right.
Under the statute, if one of the parties is interested in interpretation because there is a difference in interpretation between the two parties to the case, it can bring such matter to the court. For revision, there is a need to invoke a new fact which was not known to the parties and to the court at the moment of decision, and then it is possible to seek revision. But there is objective limit. Revision cannot be sought after 10 years since rendering of the judgment.
Okay. There are a few more cases that I would like to talk to you about, as well as general issues of international law, but we will do that after we take a short break. Do stay tuned.
खबरों का संसार।
आज के समाज के ऊपर टेलीविजन का असर बढ़ गया काफी। मीडिया पावरफुल है।
गायब है सरोकार।
10-10, 12-12 चैनल बड़े-बड़े घरानों ने खरीदे हैं। प्रिंट मीडिया की एक सीमाएं हैं।
बाजार की मार।
टेलीविजन सेलिब्रिटी का निर्माण।
मीडिया कितना जिम्मेदार?
सब चीज बॉटम लाइन पे आ गई है कि उस पर इतना खर्चा होगा, उससे कुछ मिलता है कि नहीं मिलता।
देखिए मीडिया मंथन शनिवार दोपहर 12 बजे, शाम 7:30 बजे और रविवार शाम 4 बजे।
Hello and welcome back to IST, where we have been having a fascinating conversation on the functioning of the International Court of Justice with Judge Peter Tomka, President of the ICJ. Judge Tomka, before we took a break, we were getting into the nitty-gritty of specific cases, and there's one set of cases, or one class of cases that the ICJ has taken up, which have attracted a lot of publicity, which are the advisory opinions. In your view, what is the role of advisory opinions in the as far as the court is concerned? Your advisory opinions on nuclear weapons, for example, the 1996 one, or on the illegal wall that Israel was building on Palestinian occupied territories. These advisory opinions were, I would say, widely applauded around the world, but they remain unenforced, or perhaps unenforceable. Does this mean that these opinions don't have value as far as law and international politics is concerned?
No, these are authoritative statements of the principal judicial organ of the United Nations. The role of the advisory opinion is to provide legal advice to the organ of the United Nations which has requested it, and it's then for that organ to base its action, further action, on the advice given from the court. The role of the court is to illuminate the legal aspects of sometimes political controversies, like in the case of nuclear weapons. So formally, the advisory opinions are not binding, and that's why we cannot speak about the enforcement. But the other issue is whether the organ which has requested such opinion then takes it into account in its further actions, further discussions.
The court in the Wall case invoked what I consider to be the interesting, dynamic language of the erga omnes, obligations erga omnes, obligations that are binding on all states. Does that not? Is there a possibility for this to also give rise to some kind of enforcement? I mean, for example, in the Wall case, this was a reference by the UNGA. I know that the matter went up to the Security Council where nothing happened finally, but is this then an argument which points in the direction of the GA playing a larger role as far as enforcement, quote unquote, of international decisions of this kind?
Well, obligations erga omnes, it means that not only the state which is directly affected, but also other states may invoke these obligations in relation to the state which allegedly is in breach of such an obligation, or under certain conditions can seize the International Court of Justice. We had some cases in the past which could be perceived as belonging to that category. For instance, a case concerning the obligation to prosecute those who are suspected of being responsible for torture. General Assembly is a political organ of the United Nations, so certainly discussions there have certain impact, in particular if certain resolutions are adopted by unanimity, by consensus. They may reflect the consensus of the international community as far as content of international legal rules are concerned. But General Assembly has not been assigned directly by the Charter of the United Nations the enforcement role. Under the Charter of the United Nations, in case the judgment is not complied with, the other party, that means the one which would like to have the judgment implemented, can seize the Security Council. But that avenue has not been frequently used, and of course such enforcement action is subject to adoption of appropriate decisions by the Security Council with all procedural and other aspects, constraints including right of veto in the Security Council.
Right, so that creates an
obstacle. These are reality of today's world.
Exactly. Just sticking to the Palestine-Israel issue, there's been a lot of movement in the last year to create or to define the statehood for Palestine. In your view, what is it that constitutes a state? Is Palestine a state? Could Palestine sign the ICJ statute as a state, as a member state? Or are there other hurdles that it has to overcome first?
Well, it's for member states of the international community, which is represented by the United Nations, to take steps. I know that a good number of countries have recognized Palestine as a state, over 130. Then a few years ago, I think 2 years ago, or more than 2 years ago, Palestine was granted a status of observer state in the United Nations. But Palestine is not yet member state of the United Nations, and the court...
But ICJ membership is not limited to only UN member states.
Under the Charter and the statute, and statute is an annex to the Charter, but integral part of the Charter of the United Nations, the court is open only states to states which are parties to the statute. That means states which are members of the United Nations. Non-members of the United Nations can become parties to the statute only if appropriate action is taken by the General Assembly. So for the moment, without any further action, Palestine cannot become party to the statute of the court, because Palestine has not yet been admitted to the United Nations. And as you know, members are admitted to the United Nations by the General Assembly upon recommendation coming from the Security Council. And in the Security Council, decision is subject to the rules for adoption of these decisions.
But as a non-member of the non-member of the UN, it could still approach the ICJ, as other non-member states have the right to do, right? Switzerland, for example, could have approached...
No, in case of Switzerland or Nauru, before these countries were admitted to the United Nations, there was a resolution adopted by the General Assembly which opened the opportunity for either Switzerland or Liechtenstein in the past, because Liechtenstein now is a member of the United Nations, to become party to the statute.
Right.
There is, as I said, additional step required.
Right. In the wall judgment of the Israeli wall judgment of the ICJ, there is a formulation that the right of self-determination for the Palestinians is right erga omnes, and that Israel and the rest of the world has an obligation to recognize this. Who determines whether the same right applies to other regions, say the Crimea or the Basque region? I know that there's been deliberations at the UN General Assembly which has sought to limit this right, the right of self-determination, to colonial peoples or the Palestinians, but is this a settled question in international law?
I would say that it is a very controversial issue, certainly not settled. And one has to distinguish between different situations of people who have not been given a right to realize their right to self-determination, and situations where some peoples have been living in independent countries. In case of Palestine, there is a specific situation because there was a resolution adopted by the General Assembly in 1947 which provided for establishment of two states, Jewish state Israel and Palestine, once the mandate, British mandate in Palestine was terminated.
Right. Turning to more general questions of international law, what protections does the individual, as opposed to states, have under international law? And if there are protections, then how can she or he go about seeking their enforcement?
Well, international law certainly provides protection to individuals, and there is a trend to further strengthen the protection of human rights. It started with the Universal Declaration of Human Rights adopted in 1948. Even the Charter of the United Nations in the preamble refers to human rights and human dignity. And there has been a number of international conventions elaborated and adopted by the United Nations, different covenant on civil and political rights, on economic, social and cultural rights, and on the prevention of and elimination of racial discrimination. There is a special convention on the protection of the rights of children. And these conventions have established different mechanisms for control of compliance. There are committees established which are quasi-judicial bodies. States are required to submit reports about the implementation of these international obligations. Under some of these conventions, states may also recognize the competence of these committees to receive individual complaints and deal with individual complaints. Certainly, states, once they have become parties to international covenant or treaties on human rights, conventions on human rights, they have to implement them in the domestic system. So the main avenue for protection of human rights is the national judiciary. On international plane only, this is when national systems are not effective. And then in certain parts of the world, there are regional mechanisms. In Europe, there is a European Convention on Human Rights, which established also the court, European Court of Human Rights based in Strasbourg. There is also such a regional system in Latin America, Inter-American Court of Human Rights. Later in Africa, African Charter of Human and People's Rights, and the court which was established. It's true that so far Asia is the only continent where there is no regional instrument on human rights.
We're sort of running out of time, but I can't end this interview without asking a personal question, which certainly legal scholars in India would very much want to hear your opinion on, which is that as a judge and as president of ICJ, who are the international jurists whose work over the years, whose jurisprudence you have come to admire the most?
There has been a great number of international lawyers who have greatly contributed to the development of international law. Some of them later became judges of the court, and through judicial work they had exerted great influence on international law. Others served the International Law Commission, which is the main organ of the United Nations for the codification and development of international law. So I have found particularly inspiring the work of such great legal minds like Professor Roberto Ago from Italy, who was in the commission and later judge in the court, Judge Manfred Laks from Poland, or Judge Jimenez de Arechaga, or also a great Indian judge and president of the International Court of Justice, Nagendra Singh, Dr. Nagendra Singh, who before his election to the court served also in the International Law Commission.
That's right. Well, there's plenty more that we could have spoken about, but we're completely out of time. I thank you very much for being so candid with us. I know many of the questions that are asked are quite contentious. They skirt the boundaries of law and politics, and I think you negotiated them extremely well. Dear viewers, wraps up this episode of IST. Do join us again next week, where we will have another visitor, another guest, with a different set of issues that he or she deals with for you. Thank you very much.